Everything I share today is for educational purposes only. This is not legal advice, and I am not your attorney. If your child or a minor you know is facing criminal charges, contact a licensed juvenile defense attorney in your state immediately. He was 14 years old, ninth grade. He had never been arrested before. One night, a fight broke out at a party. Someone was seriously injured. When police arrived, he was still there. He had not run. He thought cooperating was the right thing to do. 3 months later, a judge signed an order transferring his case to adult criminal court. He was tried as an adult, convicted, sentenced to 11 years in a state penitentiary where he would serve time alongside adult violent offenders. He was 14 years old. This happens in America every single year. And most parents have absolutely no idea that the moment their child is arrested, a legal process begins that could result in that child being prosecuted and sentenced exactly like an adult, with adult consequences that follow them for the rest of their lives. Today, I am going to explain exactly how the juvenile justice system works, when a child can be transferred to adult court, what constitutional protections apply, and what parents must do the moment their child is arrested. The issue: American law has long recognized that children are different from adults. Their brains are not fully developed. Their decision-making is impaired by age and immaturity. Their capacity for rehabilitation is far greater than that of adults. The entire juvenile justice system was built on this recognition that the goal of juvenile proceedings should be rehabilitation, not punishment. But that system has limits. And for certain crimes, in certain circumstances, at certain ages, the law allows and sometimes requires that a child be removed from the juvenile system entirely and prosecuted as an adult with adult consequences. The legal question is, where exactly is that line? At what age, for what crimes, and under what circumstances can the state treat a child like an adult in a criminal court? The law. The juvenile justice system in America was established in the late 1800s with the founding of the first juvenile court in Cook County, Illinois in 1899. The foundational principle was parens patriae, Latin for parent of the nation, the idea that the state has a responsibility to act in the best interest of children rather than simply punishing them. For most of its history, the juvenile system operated largely outside constitutional protections. That changed dramatically in 1967 when the Supreme Court decided in Gault. 15-year-old Gerald Gault had been committed to a juvenile detention facility for up to 6 years for making a prank phone call, a crime that would have carried a maximum fine of $50 for an adult. The Supreme Court ruled that juveniles facing delinquency proceedings that could result in confinement have constitutional rights, including the right to notice of charges, the right to counsel, the right to confront witnesses, and the right against self-incrimination. In Gault was a turning point. But the Supreme Court has continued to shape juvenile justice law in landmark decisions specifically addressing the most serious consequences. In Roper versus Simmons. In 2005, the court ruled that executing people for crimes committed under age 18 is unconstitutional, cruel and unusual punishment. In Graham versus Florida. In 2010, the court ruled that sentencing juvenile offenders to life without parole for non-homicide offenses is unconstitutional. In Miller versus Alabama in 2012, the court ruled that mandatory life without parole sentences for juvenile homicide offenders are unconstitutional. Courts must consider the individual circumstances of the juvenile before imposing such a sentence. These decisions reflect what the court has called the science of adolescent brain development. The recognition that the frontal lobe of the human brain responsible for impulse control and decision-making does not fully develop until the mid-20s. Now, the transfer to adult court. Every state has mechanisms to move juvenile cases into adult criminal court. There are three primary methods. Judicial waiver. A juvenile court judge holds a hearing and decides whether to waive juvenile court jurisdiction and transfer the case to adult court. The judge considers factors including the seriousness of the offense, the juvenile's prior record, their maturity, and their amenability to rehabilitation. Prosecutorial direct file. In many states, prosecutors have the discretion to file certain cases directly in adult court without any judicial hearing. The decision rests entirely with the prosecutor with no judicial review before the transfer occurs. Statutory exclusion. Many states have laws that automatically exclude certain offenses from juvenile court jurisdiction entirely. Murder, rape, and other serious violent felonies above certain age thresholds, often 14 or 15, are automatically tried in adult court by operation of law, regardless of any individualized assessment of the child. Real-world application. Marcus is 15 years old, living in a state with statutory exclusion laws. He is charged with armed robbery, a statutorily excluded offense in his state. Under his state's law, the charge is automatically filed in adult criminal court. No judicial hearing, no assessment of his individual circumstances, no consideration of his developmental maturity or rehabilitation potential. He is appointed a public defender who handles both adult and juvenile cases and carries a caseload of over 200 clients. Marcus meets with his attorney twice before trial. The attorney does not retain a juvenile forensic psychologist, does not investigate Marcus's childhood trauma history, does not present evidence of his intellectual functioning. Marcus is convicted, sentenced to 8 years in adult prison. He will be released at 23 years old with a felony record that affects his ability to vote, find employment, obtain housing, and access educational loans for the rest of his life. Under a different state's law, one that required judicial waiver with individualized assessment, a judge might have reviewed Marcus's background, his lack of prior record, his childhood trauma, and his scores on rehabilitation assessments, and kept his case in juvenile court, where the maximum consequence would have been commitment to a juvenile facility until age 21, with a sealed record. Same child. Same crime. Two completely different outcomes based entirely on which state he happened to live in. Common mistakes. The first mistake parents make is allowing their child to speak to police without an attorney present. Everything said in Gault applies. Juveniles have the right against self-incrimination. But juveniles are far more susceptible to police interrogation tactics than adults. Studies show juveniles are significantly more likely to give false confessions under pressure. The moment your child is detained, invoke their right to remain silent and demand an attorney before any questioning occurs. The second mistake is assuming the juvenile system will automatically be lenient. The juvenile system was designed for rehabilitation, but transfer to adult court is a real and common outcome for serious charges. Parents who assume their child will be handled gently by the system and do not retain aggressive legal representation from the beginning make a catastrophic mistake. The third mistake is not requesting a transfer hearing and presenting evidence at it. In states that use judicial waiver, the transfer hearing is one of the most critical moments in the entire case. This is where evidence of the child's background, mental health, intellectual functioning, trauma history, and rehabilitation potential must be presented. Failing to present comprehensive evidence at this hearing can result in a transfer that follows the child forever. The fourth mistake is not investigating the child's background for mitigating circumstances. Childhood trauma, mental health diagnoses, learning disabilities, exposure to domestic violence, substance abuse in the home, all of these are legally relevant to juvenile proceedings and transfer decisions. A thorough mitigation investigation conducted by a qualified juvenile forensic specialist can completely change the outcome of a case. The fifth mistake is treating a juvenile record as automatically sealed and inconsequential. While juvenile records are generally sealed and not publicly accessible, they are not invisible. Law enforcement can access them. They can be used in subsequent criminal proceedings. And records from cases transferred to adult court are public adult criminal records with all the lifelong consequences that entails. Your action steps on. The moment your child is arrested, do not allow them to answer any questions. Go to where they are being held immediately. Tell every officer clearly, "My child is invoking their right to remain silent, and we are requesting an attorney immediately." Do not let fear or a desire to cooperate override this step. 2. Retain a juvenile defense attorney immediately. Not a general criminal defense attorney, but one with specific juvenile court experience. The juvenile system has its own procedures, its own standards, and its own constitutional law. Experience in adult criminal court does not translate directly. 3. If your child is facing potential transfer to adult court, retain a juvenile forensic psychologist or mitigation specialist immediately. The transfer hearing requires expert evidence about brain development, trauma history, and rehabilitation potential. This evidence must be gathered and presented professionally. 4. Obtain every record relevant to your child's background: school records, medical records, mental health treatment records, any documentation of trauma or abuse, any prior assessments of learning disabilities or intellectual functioning. All of this is potential mitigation evidence that belongs in front of the judge making the transfer decision. 5. If your child has already been transferred and convicted in adult court, contact juvenile justice organizations about post-conviction options. The Supreme Court's decisions in Graham and Miller have created retroactive rights for many juveniles sentenced under now unconstitutional mandatory schemes. An attorney specializing in post-conviction juvenile relief may be able to seek sentence modification. Children are not small adults. The Supreme Court has said it clearly and repeatedly. Their brains are different. Their culpability is different. Their capacity for change is different. The law recognizes this, but imperfectly and inconsistently across 50 different state systems. And when a child falls into the adult criminal system, the consequences are adult consequences that no amount of growth and rehabilitation can fully erase. Know how this system works before your family ever needs this information. Because by the time you need it, the decisions are already being made. Share this with every parent who needs to understand what can happen to a child in the American criminal justice system. And for any real legal situation involving a juvenile, always speak with a licensed juvenile defense attorney in your state immediately.